Let me, Aryama Sundaram, read out what the suit argues. The suit argues that the illegal actions of invaders cannot be legalized by Parliament through this Places of Worship Act, as it infringes upon the religious rights of Hindus guaranteed under Article 25 of the Constitution. It argues that Hindu devotees cannot be prohibited by Parliament from getting back their religious place of worship through the judicial route. Do you believe, therefore, that the act itself is now being challenged in a way, Aryama Sundaram, and is that a valid challenge?
Look, let's understand three things here. Number one, there is a statute. And that statute is in force. And that statute makes it very clear that apart from the Gyanvapi Masjid, Ayodhya issue, all other places of religious worship, the status quo as in 1947 shall be maintained. That is the statute. That statute has been noticed, recognized and approved by a subsequent judgment of the Supreme Court. The Chief Justice, as he then was, himself said. That's number two. Number three, suit has been filed as a civil suit. It is not a writ petition challenging the virus of the Act. It is not a petition challenging the constitutionality of the Act or otherwise. The suit has been filed for a relief of restoration of the temple there. Now, as the Act stands, that suit cannot really be proceeded with. On the one hand, one may say that an interim order of court granted for the ASI to do it as a fact-finding issue itself, how can it be permissible? But we must remember that any interim order has to be a step in aid of the final decision of the suit. And if the final decision of the suit is towards restoration of the temple, and that can't be granted under the Act, then any interim order towards that end can equally not be passed.
No, so are you saying, Aryama Sundaram, are you saying therefore that the Act, are you saying the Act, that's exactly, are you saying that the Act has to be amended, that has to take place through a parliamentary route, and therefore the judicial route is very limited, am I correct?
The judicial route can at best be for a court exercising its extraordinary jurisdiction, writ jurisdiction, Article 226, to see the virus of the Act, to see whether the Act is constitutional, not constitutional, and looking at the legality of the Act itself. But in a suit filed, inter partes suit, filed for the purpose of restoration of a temple, the Act holds the field. And as long as that Act holds the field and is not amended, nothing contrary to the Act can be done in a civil suit.
Does it stop a survey? No, Mr. Aryama Sundaram, does it stop a survey? The Act prevents the religious character being changed. But does it stop a survey?
Good question, Rajdeep. A survey, like I said, being conducted as a fact-finding issue perhaps cannot be found fault with. The government can always order a survey if the government wants. But can it be by way of an interim order in a suit which itself cannot get the relief of restoration as a temple because it's barred by the Act? And if your final relief is that, then this cannot be used as a step in aid of a final relief which cannot be got. And if you cannot, because of the Act, restore it to a temple, then an interim order, which is an interim order can only be an order which is towards the resolution of the final dispute. An interim order cannot be in abstract of saying, look, I think it's a good idea, the ASI goes and investigates the matter. That is not an issue at all. Any interim order will have to be a step in aid for the decision of the suit. And so the interim order here given is a step in aid in decision of a suit which final relief appears as the law stands today until amendment to be barred.